proceedings. The court there conducted an authoritative analysis of the legal landscape locally and internationally. And in granting limited coverage, that court stated that it had to exercise its discretion to issue a just and equitable order while taking cognizance of its inherent power to regulate its own proceedings. This involved balancing the right to privacy against the right of freedom of expression, which, in the case of the media, translate into freedom of the press. In addition to the .com and Thatcher decisions, the two courts in this country whose decisions bind me and this court have also spoken on this subject, and I have derived valuable guidance from the decisions concerned. One such decision is from the Supreme Court of Appeal in the South African Broadcasting Corporation Limited versus Downer SC&O and others. In that matter, the SAA considered and refused an application by the SABC to televise and sound record the appeal proceedings it was due to hear. This decision was taken on appeal to the Constitutional Court, whose judgment is reported as South African Broadcasting Corporation Limited versus the National Director of Public Prosecutions. In its majority judgment, our highest court, whilst confirming the Supreme Court of Appeal decision, explored the appropriate approaches to be followed by courts when considering applications of this nature. I will revert to these decisions later in my judgment. It must be stated that when considering the exercise of the media's freedom of expression right in the courtroom, one has to confront the elephant in the room, that is the right to a fair trial, which is invariably asserted against the former right. It is that situation that confronts us in this matter. Whilst these may not have been so pronounced in the .com matter, the clash of these rights has featured prominently in the decisions of the Supreme Court of Appeal and the Constitutional Court, and how the competing rights should be balanced. Pistorius contends that the live broadcasting through audio, audiovisual, and still photographic means of his criminal trial will infringe his right to a fair trial. His view is that the mere knowledge of audio-visual equipment, especially cameras, will inhibit him as an individual as well as his witnesses when they give evidence. He has also asserted that his counsel may be inhibited in questioning witnesses and the presentation of his case. In his view, the requested broadcasting of his trial will have a direct bearing on the fairness of his trial. Pistorius contends that should the relief be granted, he will most certainly not enjoy a fair trial. His disposition is that the proposed media coverage will be inhibiting, and in view of the fact that witnesses will be subjected to searching questioning, the audio and visual recordings or still photography during the proceedings will be conspicuously intrusive and potentially distracting. He further asserts that the presence of audio-visual recording equipment and cameras in the courtroom could be conspicuously intrusive and regarded by his witnesses to be a potentially distracting feature. He further is of the view that covering his trial as is sought by the applicants will enable witnesses who are still to testify to fabricate and adapt their evidence based on their knowledge of what other witnesses have testified. Our Constitutional Court has been very vocal regarding the protection of the right to a fair trial. Indeed, any accused person who appears in a court of law facing any charge has the constitutionally guaranteed right to a fair trial, which includes the foundational values of dignity, freedom, and equality, which are central to a fair trial. In this regard, the Constitutional Court in State v. Zuguda and others, State v. Chilo, confirmed that the right to a fair trial is, and I quote, a comprehensive right and embraces a concept of substantive fairness, I close quote, and that at the heart of the right to a fair criminal trial and what infuses its purpose is for justice to be done and also to be seen to be done. There is, therefore, before me, a clear contestation of rights. In resolving that contestation, Section 173 of the Constitution enjoins me in whatever I do to ensure that the interests of justice are upheld. That section provides that, and I quote, the Constitutional Court, the Supreme Court of Appeal, and the High Court of South Africa each have the power to protect and regulate their process and to develop the common law taking into account the interest of justice, I close quotes. The Constitutional Court has given guidance to courts in general on how to go about when considering applications of this nature and upon the exercise of their powers under Section 173. In the South African Broadcasting Corporation Limited versus NDP matter, the Constitutional Court confirmed that Section 173 affirms the impartiality and independence of the courts, especially in the regard that the section recognizes the inherent power of the courts, recognize and protect their own processes. The court further confirmed that in the exercise of the inherent power in terms of Section 173, courts must ensure that primarily their proceedings are fair. The overarching objective of any court in the exercise of its power in terms of Section 173 is that the court must take into account the interests of justice. Of particular importance is what the court said in paragraph 37, and I quote, when courts exercise the power to regulate their own process, it is inevitable that the power will affect the rights enshrined in Chapter 2 of the Constitution. A court must regulate the way proceedings are conducted, and this will inevitably affect both the right to a fair trial, Section 35 of the Constitution, and the right to have disputes resolved by courts, Section 34. Courts are bound by the provisions of the Bill of Rights and therefore bear a duty to respect those rights. In exercising the power, therefore, they must take care to ensure that those rights are not unjustifiably attenuated. I close quotes. It is inevitable, therefore, that as any court goes about exercising the power, it must engage in a balancing exercise when it deals with a number of competing rights to ensure that the interests of justice are safeguarded. The phrase interest of justice does not only relate to an accused person's right to a fair trial, but also to the prosecution's right to a fair trial, and that other interested persons' rights in the same proceedings should also be promoted. As part of the court's effort to regulate the process that takes place, a practice directive was also issued by this court some time ago to regulate matters of this nature. The balancing exercise that courts must undertake is related to how and to what extent does the court allow the enjoyment of each right asserted. The right to a fair trial asserted by Pistorius, and as argued on his behalf, suggests that the freedom of expression rights to which the applicants lay claim should be attenuated and that the open justice principle should necessarily suffer the same fate. It is inevitable, as the opposition by Pistorius suggests, that in the exercise of the Balancing Act, as well as the power found in Section 173, some, if not all, the rights will inevitably be limited in one way or the other. The approach to ensuring that each right finds expression and the extent thereof was, in my view, clearly articulated by the Supreme Court of Appeal in the matter of Media Television Pty Limited versus Director of Public Prosecutions, Western Cape. And I think it's prudent that I quote what that court said. Where constitutional rights themselves have the potential to be mutually limiting, in that the full enjoyment of one necessarily curtails the full enjoyment of another and vice versa, a court must necessarily reconcile them. They cannot be reconciled by purporting to weigh the value of one right against the value of the other, and then preferring the right that is considered to be more valuable and jettisoning the other, because all protected rights have equal value. They are rather to be reconciled by recognizing a limitation upon the exercise of one right to the extent that it is necessary to do so in other, or in some cases by recognizing an appropriate limitation upon the exercise of both rights according to what is required by the particular circumstances and within the constraints that are imposed by Section 36. I close quotes. It is to this test that I have employed. It is this test that I have employed in considering the applications and the protagonists before me. My point of departure is to properly consider the objection by Pistorius to the relief sought by the applicants. In oral argument before me, I was directed to the different forms of coverage sought. What is clear, however, when one considers the opposing representations filed on behalf of Pistorius is that whilst the focal point of his opposition is directed at the live audio-visual coverage of the criminal proceedings, his opposition to the audio and still photographic coverage of the trial requires further attention. In my view, in terms of the approach suggested by the Supreme Court of Appeal in Midi, it is not open for me to look at the value of each right and disqualify one or the other. My task is to look at each right at stake and permit its enjoyment to achieve the objective for which it is asserted. In this regard, the freedom of expression right, which itself is not immune from limitation, goes a long way into complementing the open justice principle. When considering the freedom of expression right, insofar as it relates to the audio-visual request, in particular, the cautionary injunction that was mentioned by the Constitutional Court in the SABC NDPP matter, we must not lose sight of that cautionary statement. And I have, in this regard, decided to quote it in full. Before turning to the question of the order, we consider it helpful to set out some considerations which, in our view, need to be taken into account in the future when the question of televising court proceedings is raised. The time has come for courts to embrace the principle of open justice and all it implies. However, in our view, it should be borne in mind that the electronic media create some special difficulties for the principle of open justice. Broadcasting, whether by television or radio, has the potential to distort the character of the proceedings. This can happen in two ways. First, by the intense impact that television in particular has on the viewer in comparison to the print media. And second, the potential for the editing of court proceedings to convey an inaccurate reflection of what actually happened. This is particularly dangerous given that visual and audio recordings can be edited in a manner that does not disclose the fact of editing. This distorting effect needs to be guarded against. It arises not so much from the presence of cameras and microphones interfering with the court proceedings themselves, but more dangerously, it may arise from the manner in which coverage can be manipulated, often unwittingly, to produce communications which may undermine rather than support public education on the workings of the court and may also undermine the fairness of the trial. Such distortions are much more likely to arise from edited highlights packages than from full live broadcasts. I close quote. It is also instructive not to forget that the Constitutional Court itself mentioned that in exercising the power in terms of Section 173, especially to uphold the interests of justice, both accuracy and balance are necessary to ensure this. Furthermore, it is necessary to keep in mind that in the open democratic society envisaged by our Constitution, and in which the public have a right of access to the workings of the judicial system, the issue is not whether the electronic broadcast or print media should be allowed to cover about how the court functions when dealing with proceedings before them. I am not persuaded that the objection by Pistorius to the coverage of his pending criminal trial should be jettisoned to the extent he suggests. I have found merit in the argument on behalf of the applicants that acceding to the objection by Pistorius fully will perpetuate the situation that only a small segment of the community is able to be kept informed about what happens in courtrooms because of this minority's access to tools such as Twitter, for example. According to that argument, this will also perpetuate the reality that the community at large remains dependent for news on what happens in the courtroom from the summarized versions of the journalists and reporters who follow these proceedings. These summarized versions or accounts have, in my view, been correctly categorized as second-hand, liable to be inaccurate as they also depend on the understanding and views of the reporter or journalist covering the proceedings. My views to the objections raised by Pistorius find support in the open justice principle. Allowing the objections in their entirety will surely jettison the noble objectives of the principle of open justice when one takes cognizance of our development in the democratic path. At this day and age, I cannot countenance a stance that seeks to entrench the workings of the justice system away from the public domain. Court proceedings are in fact public, and this objective must be recognized. Our Constitution is underpinned by a number of values, and for purposes of this case, I refer to openness and accountability as found in Section 1D, which provides that the Republic of South Africa is a democratic state founded upon a number of values, including a multi-party system of democratic government to ensure accountability, responsiveness, and openness. In this regard, it is also important to take cognizance of the fact that Sections 34 and 35(3)(c) make it very clear that even criminal proceedings in this country are to be public. The basis for this is that courts of law exercise public power over citizens, and for this it is important that proceedings be open, as this encourages public understanding as well as accountability. I refer in this regard to what the Constitutional Court said in the matter of State versus Mamabulo. It is also worth our while to take cognizance of what the House of Lords has said in this regard in the matter of McCann Teckington Breen versus Times Newspapers Limited, to the effect that, I quote, "In a modern, developed society, it is only a small minority of citizens who can participate directly in the discussions and decisions which shape the public life of that society. The majority cannot participate in the public life of their society if they are not alerted to and informed about matters which call or may call for consideration in action. It is very largely through the media that they will be so alerted and informed. The proper functioning of a modern participatory democracy requires that the media be free, active, professional, and inquiring." Clearly, therefore, the freedom of expression right, as well as the open justice principle, visual recording equipment, as well as the knowledge and awareness thereof by himself as an accused person and by his witnesses, will be great when they give their evidence. This potential was recognized by our highest court in the SABC versus NDPP matter. For this reason, I am of the view that the objection, insofar as it relates to audio-visual or televising and still photography of Pistorius and his witnesses when they testify, has the potential to deprive him of a fair trial on the grounds spelled out in argument on his behalf. I am persuaded that there is merit in his fears and that of his witnesses, that they may be disabled somewhat in giving evidence. I treat this situation similarly to how I've discussed the audiovisual request. On the other hand, however, audio coverage, in my view, does not carry the inhibitory or intrusive potential as the audiovisual form of coverage. In my view, whilst there may be no visual image of Pistorius and his witnesses when they testify, they should, however, be heard on radio. I have further considered the extensive interest that the pending criminal trial has evoked in the local and international communities, as well as media circles. It is, in my view, in the public interest that, within allowable limits, the goings-on during the trial be covered as I have come to decide, to ensure that a greater number of persons in the community who are unable to attend these proceedings are able to follow wherever they may be. Moreover, in a country like ours, where democracy is still somewhat young, and the perceptions that continue to persist in the larger section of South African society, particularly those who are poor and who have found it difficult to access the justice system, that they should have a first-hand account of the proceedings involving a local and international icon. I have taken judicial notice of the fact that part of the perception that I alluded to is to the fact that the justice system is still perceived as treating the rich and famous with kid gloves, whilst being harsh on the poor and vulnerable. Enabling a larger South African society to follow firsthand the criminal proceedings which involve a celebrity, so to speak, will go a long way into dispelling these negative and unfounded perceptions about the justice system, and will inform and educate society regarding the conduct of criminal proceedings. I must hasten to mention that the decision I have come to should be embraced with the objective I have spelled out in this judgment. I mentioned in this regard that the reason that I mention this for the reason that it has come to my attention that there are media houses that intend to establish so-called 24-hour channels dedicated to the trial only, and that panels of legal experts and, in certain instances, retired judges may be assembled to discuss and analyze the proceedings as they unfold. Because of these intentions, it behoves me to reiterate that there is only one court that will have the duty to analyze and pass judgment in this matter, and it is this court. The so-called trial by media inclinations cannot be in the interest of justice as required in this matter and have the potential to seriously undermine the court proceedings that will soon start. Despite the order that I have arrived at, it must be understood that the presiding judge over the criminal trial retains the ultimate discretion during the trial regarding aspects of the relief granted in this matter, which may require her attention as the trial unfolds. I have also considered the compromise position that I mentioned earlier, reached by all the applicants with the Director of Public Prosecutions. In the circumstances, the following order is granted. The applicants under case number 10193 of 14, that is MultiChoice Pty Limited, Combined Artists Production, CC and Prime Media Broadcasting, a division of Prime Media Pty Limited, and I refer to them as the MultiChoice and Prime Media applicants, or their authorized representatives, are permitted to set up equipment in accordance with the specifications that I mentioned below to obtain a video and audio recording and or transmission of the permitted portions as indicated in this order of the criminal trial of Oscar Pistorius under case number 13/25513. 2. The technical equipment shall comply with the following specifications. 3 cameras, as depicted in Annex A, shall be installed in the courtroom where the trial is to take place at least 72 hours before the trial commences. The cameras shall be installed in locations in the courtroom which are as unobtrusive as possible, and so that the proceedings are not interfered with. The locations of the cameras shall be substantially in the areas of the courtroom indicated in Annex B. The cameras shall be remotely controlled from a control room, and no camera personnel are permitted to be present in the courtroom to operate these cameras during the trial. The cameras must be preset to ensure that no extreme close-ups of any witnesses, legal representatives, the presiding judge, or any person in attendance at the trial takes place. The equipment is not permitted to record in any manner any confidential communication between legal representatives or between clients and their legal representatives, or any bench discussions between the judge and any lay assessors that may be appointed. The presiding judge shall specifically direct when recording should start and when it should stop. The equipment shall be deactivated so that no recording whatsoever can take place while the court is not in session, including any breaks such as lunch and tea breaks, and during time before the court is in session and after the judge has adjourned the trial at the end of each day. The cameras shall not be accompanied by any movie lights, flash attachments, or artificial lighting devices, and no visible or audible light or signal is permitted. MultiChoice and Prime Media may install their own audio recording system, provided that this is unobtrusive, and does not interfere with the proceedings. The Judge President and/or the Deputy Judge President and the trial judge and/or the court manager may visit the control room to check how the recorded images would appear on the TV screens when broadcast, and to give directions regarding the images to be broadcast to avoid extreme close-ups. I now deal with the portions of the trial that may be recorded and broadcast. In the first place, MultiChoice and Prime Media are permitted to broadcast the audio recording of the entire trial in live transmissions, delayed broadcasts, and/or extracts of the proceedings. MultiChoice and Prime Media are permitted to broadcast audiovisual images from the following portions of the trial only: in live transmissions, delayed broadcasts, and/or extracts from the proceedings. 1, opening arguments on behalf of the state and on behalf of the accused, any interlocutory applications during the trial, the evidence of all experts called to give evidence for the state, excluding evidence of the accused and his witnesses, the evidence of any police officer or former police officer in relation to the crime scene, the evidence of all other witnesses for the state, unless such a witness does not consent to such recording and broadcasting, and the presiding judge rules that no such recording and broadcasting can take place. Closing argument of the state and of the accused, delivery of the judgment on the merits, and delivery of the judgment on sentence, if applicable. Any witness whose testimony is to be broadcast in audio-visual form may subject his or her consent to such broadcast to reasonable conditions, which shall be communicated to MultiChoice and Prime Media or their representatives by the state, including the broadcasting of the evidence from behind with the face of the witness obscured from public view, the broadcasting of the evidence from the front but with the face of the witness obscured from public view, the broadcasting of the evidence only by way of a wide shot, that is, the central camera placed at the back of the courtroom would depict the entire courtroom with the judge at the center of the image and the witness only visible in the background. Objections by witnesses to the audio-visual recording of their evidence shall be in writing and will be served on the Director of Public Prosecutions and the accused attorney and be delivered to the office of the Deputy Judge President at least 24 hours before the testimony of the said witness to avoid delaying the trial. The Judge President and/or the Deputy Judge President shall first deal with the said objections in chambers, and if same cannot be resolved, the presiding judge shall make a final ruling on the issues after hearing the parties. The print media applicants or their authorized representatives are granted permission to set up equipment to obtain still photography of the criminal trial, subject to the following conditions. 2, still photography cameras will be fixed at locations within the courtroom. These will be used for purposes of taking and publishing still photographs of the court proceedings during the trial, subject to the following provisos. The cameras shall be installed in locations in the courtroom which are as unobtrusive as possible and so that the proceedings are not interfered with. Each of the cameras shall be controlled by one of the applicant's representatives, who will at all times remain behind the cameras while court is in process. The aforesaid cameras may not be moved while the court is in session, and no changes of lenses or film shall be permitted while the court is in session. No extreme close-up photographs of any witness, legal representative, the presiding judge, or any person in attendance at the trial shall be taken. Flash photographs shall not be permitted. No artificial lighting devices and visible or audible lights or signal shall be permitted. No cabling for the cameras on the floor of the court shall be permitted. No identifying names, marks, logos, symbols may be used in any equipment or clothing worn by the representatives of the applicants. The applicants are permitted to take still photographs during the entire course of the trial, excluding the accused and his witnesses only when they testify, provided that witnesses other than expect witnesses for the state or police officers or former police officers who testify at the trial may object to being photographed while giving evidence, and if the presiding judge rules that such witness may not be photographed while giving evidence, the applicant shall refrain from doing so. Alternatively, may subject his or her consent to reasonable conditions, including that his face or her face be obscured in any photograph published, or that only wide-angle photographs of him or her are allowed, meaning photographs that include not only the witness but as much the physical surrounds of the courtroom as is technically possible. Notwithstanding the above, and in the event that it becomes apparent that the still photography is impeding or will impede a particular witness' right to privacy, dignity, or the accused's right to a fair trial, the court may, after hearing all interested parties, direct the cessation of photography. The applicants are to make available at no cost and in clean form with no logos the still photographs referred to above to any media organization requesting same. The court may, on good cause shown, withdraw the leave or change the conditions I have mentioned. Furthermore, notwithstanding the above, the presiding judge shall retain a discretion to direct that in the event that it becomes apparent that the presence of the cameras or the recording and or transmitting and or broadcasting is impeding a particular witness's right to privacy, dignity, or the accused's right to a fair trial, MultiChoice and Prime Media and the print media will be directed to cease recording and or taking still photographs and or transmitting and or broadcasting the testimony. MultiChoice and print media are directed to make the feed from the authorized broadcast referred to above available free of charge to the applicants under case number 51545/13, that is the ETV applicants, and any other broadcaster in clean form that is free of any logos. There is no order as to costs. I hand down the judgment. Court adjourns.
Now that was Justice Dunstan Mlambo handing down that judgment. We will take a break and we'll be coming back right now.